Hello, my name is Tom Ryan of Ryan LLP, and here's a brief overview of the discovery process in civil lawsuits. Discovery is the general term given to the exchange of information between parties to a lawsuit. In Ohio, there's a formal system by parties follow to exchange this information, which are outlined in the Ohio Rules of Civil Procedure. The purpose of discovery is to allow each side to obtain facts and learn opposing parties' view of the dispute. The most common discovery requests are interrogatories, requests for production of documents, and depositions. Interrogatories are written questions that are directed to the opposing party of the lawsuit. The interrogatories will specifically be drafted based upon issues and known factual evidence of your case. For example, if your case involves a car accident, the interrogatories will typically include questions focusing upon the individual drivers, the facts of the accident, the injuries sustained, and any insurance coverage available. Usually a party has 28 days to complete and return interrogatories to the requesting individual. Requests for production of documents are written requests to obtain data related to the case. The definition of documents is quite broad and can generally include any form of tangible evidence, including electronically stored information such as emails or text messages. There is no limit to the amount of information that can be requested as long as it is reasonably related to the case. Depositions are conferences between the parties where one party conducts questioning of a witness or a party as if they were in the courtroom. They are usually conducted in a conference room at the attorney's office. The questions and answers are transcribed by a court reporter. Some depositions are also conducted by a video. The party to be deposed is known as the deponent. They are placed under oath and asked a series of questions regarding information relevant to the lawsuit. The topics may include the history of the deponent, educational background, work history, and knowledge regarding the facts of the case. Generally, the deponent is required to answer all questions, even if the question would not be admissible at the time of trial. In addition to interrogatories, requests for production of documents, and depositions, there are a few other discovery-related materials. These include stipulations, admissions, and physical and mental exams of persons. These are less common, but may be used in your case if the issues or disputed facts require them. Requests for admissions are meant to reduce disputed facts in a case. Admissions usually involve facts that are clearly not in dispute, but may have an impact on the evidence at trial. Examples include the accuracy of photocopied documents or the owner of a vehicle involved in an accident. If admissions are not expressly denied within 28 days after they're served, they're deemed admitted. Physical or mental exams occur when the mental status or physical characteristics of a party or a witness is disputed. An example of this rule being utilized is when the severity of an injury is in dispute. A defendant may request an independent medical exam to determine whether the injury has resolved or whether there will be additional treatments necessary into the future. Once the discovery period is over, the case will proceed to the dispositive motion phase, usually in the form of a summary judgment motion.